Welcome to week 4. We're already getting to almost a third of the course. So we're trucking through. Now last week we started looking at the elements of contract formation and we covered offer and acceptance, but we didn't quite get to consideration. So we're going to cover that this evening and then move on to the week 4 lecture after that. Now we know that an offer and acceptance is required for an agreement to exist. But the agreement by itself isn't enough for a contract to be legally binding or enforceable. So we also need to have something that underpins that. And one of those things is consideration. So it's the value of the promises that the two parties are exchanging or the multiple parties are exchanging. And that promise can be financial. So we can see it most relevantly with the transfer of money for the exchange of goods. But consideration can also be the forbearance from doing something. So you agree to not do something by agreeing or promising that. That's also good consideration. So that's what we're looking at now. It's an element of the entire contract formation picture. So we looked at offer and acceptance last week. And then tonight we'll look at consideration and we'll make 2, intention to create legal relations, which is our last element of formation. This will be on your research assignment. There will be a question that asks you to talk about contract formation and whether, from the fact pattern, a contract has been formed or not. So we're looking at something that's enforceable. And then in the few weeks following, we'll start to look at the formalities around consent and vitiating factors, such as misleading and deceptive conduct and things like that. So my drawings are really good. As you can see, I'm an artist of a terrible kind, but we've got purest form, a watch being transferred for some currency that's green, so it's probably American. But it's the price or the promise of something. Now, it can be a commitment, but what we need to see is that commitment coming from a promisor to a promisee. So it's similar language that we saw in offerer and offeree in that concept. Now, simple contracts require consideration to be legally binding. However, don't mix this in with what we call deeds. If you have a deed, a contract that's a deed, which is a really formal document, such as a deed of confidentiality, deed of marriage, consideration is not required for a deed. So if you're ever looking to just sign some promises and not worry about consideration, you enter the deed, which is a formal thing. In this course, we do not go into detail about deeds. So we're looking more at the simple, verbal or written contracts. Don't worry about deeds. But know that if you do have a deed, it doesn't need consideration. It just needs signatures. So we've got a few rules of consideration. When you are looking at a formation question, it is best to identify the rules that you're going to be applying. So we might have 6 rules of consideration. But that doesn't mean that you write out all 6 rules in your paper. What we want you to do is identify the rules that are relevant to the fact pattern. So here we've got a case called Hammer and Sidway, and we can call this our first rule. Consideration is doing something, or it can be forbearing from doing something. So here we have a nephew who's agreeing to refrain from drinking, smoking, and gambling for a period of time until he turns 21. And if he refrains from doing those things, his uncle will pay him $5,000. That's the agreement. $5,000 and you will not drink, smoke or swear or gamble. So this nephew has held up his end of the bargain and has refrained from drinking, smoking, gambling and swearing. And he goes to his uncle and says, well, I've upheld my part of the deal. Pay me the $5,000, please. In this situation, the uncle said, yes, but I still don't think you're responsible enough to handle the money, so I'm going to put it in a trust. And a trust is kind of putting it in a place that he'll be able to access at a later stage. Anyway, in between the trust money being released to the nephew, the uncle's passed away. And the estate has gone, well, there's no valid contract here. We're not going to release that $5,000 on trust to you. So they're arguing there's no consideration. You were doing something you were already required to do in a way, underage, you shouldn't drink, you shouldn't smoke, it's not good for you. But what the courts are saying is that doing something or not doing something can be good consideration. And in this case, the fact from restraining from doing something that you like is enough to be considered good consideration. Even if it was for his benefit. He had a health benefit from it. The act of forbearance is good consideration. So that's our first rule. Now, what I mean by that, though, in terms of the research assignment, is you do not need to bring this rule up unless there's something in the fact pattern that is about forbearance, about someone not doing something. So in your fact pattern, if you've got a question that says, Billy agreed not to do this, whatever it is, X. If that happens, I want to see you reference Hammer and Sidway as a rule to tell us that, well, consideration can be forbearance. And then we go through the other rules and we identify which ones are relevant. So let's do that now. A second rule of consideration is that past consideration is not good or sufficient. What this means is that you may finalise a contract. You may go through the offer acceptance, you've got intention, and you pay your money. The contract's been finalised. But after the contract's been finalised, there might be a conversation, adding some facts to the situation. That conversation that happens after the contract's been crystallised or finalised is not binding because it doesn't have any consideration attached to it. And here we have an example of Roscola and Thomas where the plaintiff is buying this horse from Thomas. And the contract's completed, the money is paid, and the horse is handed over. But after this transaction's occurred, Roscola asks Thomas for some assurances about the horse's condition. He goes, is the horse free of vice? And it turns out the horse is very vicious. I don't know how, but it's not suitable for the purpose it's been purchased for. Now, this statement that, yes, I assure you that the horse is fine, happened after the contract's been formed. So the courts are saying, well, you've paid consideration for the transaction, but you have not paid consideration for the assurance afterwards. So that assurance would be a second contract that's not binding. So you cannot reuse consideration for other contracts. Past consideration is not good consideration. So that's why it's incredibly important that you identify when the contract's been finalised initially. Because then if something happens afterwards, you need to have fresh consideration. Yes, that's right. But you can see that the promise came afterwards wasn't supported with something going reciprocally the other way. If he had given him $1 or 50 cents, we could see sufficient consideration because the value of it doesn't matter. We've seen a case that a chocolate wrapper is good consideration. It just has to be something that's transferring. We can see this in an example again in an employment circumstance where Anderson and Glass, we've got an employee saying, you know what, guys, you've worked really hard all year. I'm going to give you a wage increase for that work that you did. Now, those wages were to be paid in the future, not retrospectively paid back or backdated. Now, the question the court wanted to address is, well, is work completed previously good consideration for a new promise? And they're saying, no, that's unenforceable because retrospectively the contract's already been performed. It's past consideration. Yep, so we've got an employee and an employer. The employee has already done the work. It's completed. And the employer goes, you know what, you've done a great job. I'm going to pay you some more money. But I'm going to increase your wage moving forward. But it's in the books as backdated. So it's a bit of a weird setup. But the main message from this is that the work that was done previously has already been paid for in good consideration. The promise to pay more for the work that has already been completed is unenforceable. The work moving forward, though, the pay increase is enforceable. So if they've agreed to a $100 bonus, $100 an hour increase, that's a lot. But moving forward, it's enforceable. But it's not enforceable for the work that's already been completed under pure contract consideration law. So a promise to increase wages retrospectively is unenforceable because the consideration is past, the act of working. And there's a like case that we'll see that talks about some of the public policy reasons for that. And we'll get to that as we go through. How could this have been remedied? What would the worker need to have done? It's a bit of a trick question. Past consideration, they need to do something in exchange, so really it's only moving forward. Or you enter another agreement and the employee pays some money to each other, or something like that. Alternatively, what could we do? We could enter a deed. Formal deed removes the need for consideration. But for our purposes, the rule is that past consideration is not good consideration. Consideration has to come between the parties in what we call, or what is known as the privity of contract. What this means is that someone outside of the contract is unable to enforce it. So let's say that I hire someone to mow my grandparents' lawn. Now, my grandparents are getting the benefit of this contract because their lawn's being mowed, but the contract is actually between me and the person I've hired to mow that lawn. So if they don't mow that lawn and it becomes an overgrown mess, my grandparents can't sue them for the loss because there's no contract. The only person that can sue are the two parties that have entered into the agreement and transferred the consideration. So the consideration or the action itself can go to another party, but you need to see at least one of the promises going to that party that's going to be conducting that activity. The privity of contract. So here we've got a manufacturer who sells to a wholesaler, and that wholesaler then on-sells to someone who is a retailer, so they sell it to the public. In this case, there's no contract between the manufacturer and the retailer, purely. So if the retailer doesn't follow what we call a recommended retail price, the manufacturer can't, under contract, sue them. They can only come after the wholesaler. And in this case, we've got Dunlop Tyres, who are selling their tyres to Jew, a wholesaler. And as part of this contract, they've got a requirement that tyres not be sold for a price that's below the recommended retail price, price tying. And then Jew has then on-sold the tyres to Selfridge, but has not required them to follow the recommended retailing price. So Selfridge, which is a big retailer, it's like Myer or Kmart in England, have just sold the tyre for any price that they like. Now Dunlop's not happy with this because those recommended retail prices are there for a reason, part of their competition, part of their sales schemes. So they've gone after Selfridges in a lawsuit to say breach of contract. Now the court said, well, Dunlop can't enforce that because of privity of contract. The only person that they can go after is Jew, the wholesaler. So they can't make Selfridge sell the tyre at a certain price. Now what would they have done better in a future case? They would have put a clause in Jew's contract to say that you're responsible for anyone that you then supply to. And then Jew would have had a legal obligation to put an agreement in place with Selfridge. So you try and transfer the obligations that way. But there's still the issue of privity of contract in terms of enforcing your recommended retail price against the final retailer. You'd still have to go through Jew first. So privity of contract is a very important concept. You can't sue someone that's outside of the contractual requirements. You could think of a circumstance of why, because if you just made obligations about someone who didn't even sign up to those agreements, how unfair would that be? They weren't probably aware of the requirements. It's like saying, yep, I'm agreeing on that person's behalf, and they don't even know it, but they're going to be bound by it. So that's why privity of contract exists. Fourth rule, consideration can be nominal. What this means is that consideration, the value of it, does not matter. It can be $1, it can be 15 cents. As long as it is the exchange of something. And in Thomas and Thomas, we have a circumstance where the husband's passed away. And he's asked his estate to enable his wife to live in that house for the rest of her life. And to do that, they've paid what we call a peppercorn rent of £1 a year, so that there's good consideration underpinning the agreement to lease that house out. Anyway, the executor later changed his mind and tried to kick Miss Thomas out by saying that the consideration was inadequate to form a binding contract. Now, the courts are saying that doesn't matter because they don't want to get involved in the commercial realities of a contract. There is that principle that the parties are free to contract on terms that suits them. So they're not going to get involved in the bargain or the value of the bargain, because that's up to the parties, unless there's some element of unfairness in the way that the contract is formed, such as duress, or the terms are so uncertain or so ambiguous that they need to imply other terms in. But they won't get involved. Freedom of contract. The two parties are free to choose and agree on the terms that they wish. Now, another reason for that is because if the courts had to assess whether consideration was something of market value or sufficient every time, you can imagine how much time that would take and the arguments around, well, how much is it actually, what is the market rate for the rental here? You can work it out, but again, it still creates a situation where there's arguments. So although £1 for rent is uncommercial, it's still something that's identifiable. So that contract had consideration and therefore was enforceable. Similarly, in Nestle, Chappell & Co. Limited and Nestle, this case tells us that chocolate wrappers are good consideration. That means you've had your chocolate and you've handed over a chocolate bar wrapper. That can be good consideration. In this case, it was a bit of a promotion where you ate, I think, 3 chocolate bars, collected them, and then you paid about £1 or £1.06, and swapped that, and in exchange you'd get a record, one of the old vinyl records. Now, the reason why the chocolate bar wrappers were important was that the value of the consideration for the exchange of the record was used to calculate the amount of royalties. So the courts actually put a value on those chocolate wrappers for the purpose of calculating those royalties. Don't worry about the calculation thing, but just note that consideration can be nominal, can be anything that's tangible and identifiable. Which brings us to Rule 5. Has to be something that is tangible. In White and Blewett, sorry, my accent keeps changing. In White and Blewett, we've got this situation where a dad has loaned some money to his son. Now, as part of this, he's made his son sign an IOU to say, yep, I'll pay it back. Now, this son's been treated unfairly, he believes, in comparison to his other siblings who have also borrowed money but have not been required to sign such a document. So the son decides to harass the dad to a stage where he goes, all right, I'll forgive the debt if you just stop harassing me. So what's that consideration there? Forgiveness of debt in exchange for forbearance from harassment. Now the dad's died, and the executors then used the promissory note to say you pay up to the estate, you owe the estate money. Now, the forgiveness of debt here, the question is whether it's valid, and the courts are saying no, because the ceasing of harassment is something that is so illusory. How do you define harassment in a consideration aspect? So it's not tangible, it's not identifiable. So undertaking to cease harassment is too nebulous and vague. It's important that it's vague, it's unable to be quantified or identified. So son did have to pay back in those circumstances. Compare this with a circumstance where you agree to mow someone's lawn. You can see there that there's enough to identify what the promise is. The term harassment, not so much. You won't come up against many situations where the consideration is not tangible, but just know that this is a rule of consideration. similarly to past consideration, but they've just titled it a bit differently. Rule 6, consideration must be legally sufficient. And it does tie into nominal aspects as well. But what Stilk and Myrick are saying, and this is, although it's a 200-year case, it's still something that underpins the formation of contracts still today. And a lot of the laws are built on this. But if you've got an existing legal obligation, similarly to your employment contract, that existing legal obligation is not good consideration. So here we've got a ship and a ship crew. And on the voyage, what happens is that some of the seamen or the individuals that are sailing this ship decide to desert a long way from home. And the captain's quite worried. He's going, I don't have enough people to sail this back, but I'll make an agreement with you. If you guys get the ship back, I will give you some extra money because of the additional work that you'll have to do. You'll be on more shifts because we're 2 men short. You'll be doing extra lifting, but you get that boat back, I'll pay you some extra money. Now, they get back home to London, and the captain decides not to pay. And they sue him, of course. And the question that we're asking is, well, can the performance of an existing contractual duty be a good consideration in exchange for a promise? We saw from Rule 2 that it can't. Similarly, they held in 1809 that it was not legally enforceable because the crew were already contractually obliged to bring the ship home. Now, I think that's a little bit rough, to be honest. I think if that went to court now, it would be found differently. The fact that they're adding additional work to their obligation, so they're going to be working probably an extra 3-4 hours a day, perhaps. I think that that additional work is enough to be considered good consideration to overcome this existing legal obligation. But the general rule is, if you've got an existing legal obligation, that's not good consideration for a new agreement. That being extra money. And the reason why this is the general rule is predominantly from a public policy aspect. And what they're saying is that employees shouldn't be able to hold employers to ransom in circumstances where that additional work is required. We've all worked in jobs or been in situations where you've had to work a few extra hours, and sometimes your contract accounts for that in terms of overtime. But if every time you worked an extra 15 minutes or something like that, you were able to go back to your boss and renegotiate, it would create quite a circumstance where would have flooded courtrooms. So they're saying that if that's the existing legal obligation, you're already bound by it. Consideration's already there. It's not new. And this is to prevent blackmail, they say. Yep. So the question is, in a sales type arrangement where you're not paid for your performance until the books, or until the pay. Yep, so you might have payment on intervals. In those circumstances, the contract would be dealing with it. It'd be expressed in how those payments are made, what they're made for. And generally speaking, in pure employment law, if you're making promises about this, the contract stuff's probably overridden. But the principles from contract are what we use generally. But from a sales role, that would be captured in the contract. One thing we know with these contracts is there's nothing contemplated as such in the main contract. It's something that's been added in additionally after the main contract's already been formed. Because it's additional, we don't have good consideration for it in a pure common law, contract law aspect. So performing a duty you are already bound to perform is not good consideration for any promise that is made for that. And that's to stop blackmailer. And perhaps probably a clearer case for us is Collins and Godfrey, where let's say you've got a specific legal obligation. A legal obligation is don't speed, for example. Now, if you've got a legal obligation to do something, it's not good consideration in exchange for another promise, because then you can't go and say, well, I promise not to speed. That's good consideration. Because you already have to do it. And in this case, although we're talking 1831, it's still good law. We've got Collins who has received a subpoena. Has anyone received a subpoena before? A few? It's literally a court order. And if you don't comply with it, you're in trouble. It's a legal obligation. So he had to attend the court by law anyway, but what happened in this case is Godfrey has said, well, I need your evidence for my case. I'll pay you 6 guinea. I don't even know what 6 guineas worth, but that's what he was going to pay. For you to attend court and give evidence. Now, he did attend court. He sat in the courtroom for 4 days, but didn't actually ever give any evidence. So Godfrey decides, you know, I'm not going to pay you. And then they go to court themselves. And the question is, well, is this agreement supported with valuable consideration? And the courts are saying, no, it's not, because the subpoena already created that legal obligation to be there. That legal obligation is then not good consideration for entering the contract. Didn't have to pay the 6 guinea. So that's really quick overview of consideration in terms of the rules. Now, as I was saying, only pick the rules that are applicable to your fact pattern in the research assignment. Don't need to go through all 6 because you know what, some of them won't be relevant. But let's think about consideration. It is required for simple contracts, verbal or written, not deeds. You do not need consideration for a deed. It doesn't have to be market value. It can be nominal. It just has to be something that is identifiable. It can be positive or it could be negative. And what we mean by that is doing something versus not doing something. It has to come from or go from the party wanting to enforce the agreement. And that's what we mean by the doctrine of privity. It has to go from one of the parties that wants to enforce the agreement to the other. And then that other party may perform consideration that is for the benefit of someone else, but at least one of the promises has to go from one of the parties. Has to be clear, has to be legal. So a promise to steal or kill someone is not good consideration, some would say, and cannot be past consideration, so something that you've already done. Now, where consideration can get a bit muddy is in this circumstance of discharging an existing obligation that you may have. And from this example, or from this, what we're looking at is where someone owes a debt, and then you make a promise with each other to pay a lesser amount, but you'll pay it out earlier or quicker. Or sometimes commercially, it's good to accept a lesser debt because at least you're going to get something rather than sending the other person bankrupt. So instead of taking the whole $100,000, you might make an agreement and say, all right, I'll take $90,000. That's all you can afford, and then that's it, we're done. We've resolved that dispute. The question there, though, is when we've made that agreement, is there a consideration to enforce that particular agreement? Because what we've got there is past consideration. You already owed the money. So it does create a circumstance where a debt is owed, there's an agreement to accept a lesser payment, they pay that debt, or that lesser amount. The question comes back, well, can the creditor then change their mind and say, I want the rest of the $10,000 because we didn't have a binding contract? Technically, under the rules that we've seen, that would be what happened. And the case we've got is Folks and Beer, 1884. So Dr. Folks owes Mrs. Beer £2,000 pounds and 19 shillings, £2,090 and 19 shillings. They go to court over this amount, and there's a court order in her favour. But outside of court, they agree to a payment plan because he can't afford to pay this up front. So they agreed that he would pay £500 immediately, and then he'd go on a payment plan to pay £150 every 6 months until the debt was paid off. And in return for this payment plan, Mrs. Beer wouldn't take any action. You do this, I won't go back to court and sue you for it. Now, this agreement made no reference to the interest payments that the contract referred to, or that when you go to court and you get an order is relevant. So if you get a court order and you don't pay it within time, interest starts to build up on it. He's paid off the entire amount over those 6 monthly payments. But then Mrs. Beers turned around and said, you know what? I want my interest. The debt was not paid off immediately. Pay off the rest of my interest. So folks is arguing, well, the agreement was a contractual arrangement. Had made no mention of the interest, so when I've paid off the payments, it's all finished. And then Bear saying, well, the contract's invalid because there's no consideration. So the issue, is partial payment of a debt sufficient consideration for the original contract? And as we saw from the rules of consideration, past consideration is not good consideration, so he had to pay the interest on top. This creates quite an unfair circumstance because you think you've got a promise and then they can turn around and renege on that promise because there's no consideration. Now we'll see as we get into the week 4 content, there is something called promissory estoppel that might step in as an equitable remedy to resolve promises like this. But technically, the creditor can renege on their promise because the consideration is not fresh. The courts have given us some exceptions to the rule over time since that case was originally heard in 1884. First being is that if you change the way that you make the payment so that it is a little bit harder, that element of difficulty can be good consideration. So let's say you were originally paying by cash. To make that promise enforceable, you might change to bank transfer. And the reason why that's good consideration is because you have to then take time to set up the bank transfer. That action of, even though it's 2 minutes, 1 minute, doesn't have to be, remember, it's just nominal. That action itself is good consideration. So what's that mean? If you're paying off debt on a payment plan and agreed to pay off less, change the way you pay. Or, I think this is the best way, give some extra consideration to make that promise binding. So at the time you're entering into that agreement, give them $1 on top of everything else. Notice that he did give $500 immediately, but if you just gave another $1 and said specifically this $1 is in consideration of the mutual promises, that agreement would have been binding. The courts won't allow a creditor to renege in circumstances, however, where a third party pays the debt. So let's take this example of Hirachand and Temple, where we've got a Lieutenant Temple stationed in India taking a loan, and then what happened was that he didn't pay, so the Indian company Hirachand, Punamchand, called his father, as you do. Your son owes me money, can you pay? They did pay in a way that was less than the total amount. So they made an agreement on a lesser amount to fully satisfy the debt. And then the Indian firm decided to go after the son for the rest of it. Anyway, the courts are saying, well, if there's a third party involved and they're making this promise based on an understanding that you're not going to go after the individual, you have to be held by that. So that's an exception there if part payment is made by a third party. Another exception is if you just sign a deed. No consideration required. Or my favourite, promissory estoppel, which is an equitable rule that prevents an unjust departure from an assumption of fact. And we'll go through how you identify or prove promissory estoppel in the next lecture. Any questions about consideration? No. Just has to be something exchanged. Promise, for a promise. If you don't have consideration, technically, you don't have a contract that's legally enforceable, unless there's some exceptions to the rule. We'll come back to the Kahoot, I think, after promissory estoppel, because I think it's a good segue. And then also get us through an extra 15.